thing that I think comes up in your industry is the borrowed employee concept. And that's where they're not your employee, they're somebody else's employee, but you need them for a short period of time and you borrow them. So actually this kind of goes back to what Nevin was talking about, because the example that we see in case law is when you're leasing equipment. Okay, so we don't have the middleman in this particular situation. You're just literally leasing a piece of equipment from an equipment operator. And as with that lease comes the operator. Okay, so is that operator your employee or the equipment company's employee? Generally, it's the equipment company's employee. But again, make sure if you're leasing equipment and a person is coming along with that equipment, that equipment company has workers' comp insurance. So the agricultural exception. I mean, this is how an agricultural worker is defined in the Act. It's pretty expansive, covers all of you, covers what's done on your farms. But the exception is not expansive. So children, a lot of you mentioned family members. Children, if they're under the age of 18, are excluded from coverage under the Workers' Comp Act. They're not considered to be employees. And spouses are technically not considered to be employees. Everybody else, though, is probably going to be, because this is what they say. You have to provide coverage if you're otherwise covered by the Act. And guess what? You're otherwise covered by the Act if you pay wages to one person. That's it, okay? You pay wages to one worker totaling $1,200 or more. That's not hard to meet. Or you provide work to one worker for 30 or more days. Again, that's not hard to meet. And if one person on your farm, at your facility, at your business meets that $1,200 threshold, everybody has to be covered. Okay, so the test is only for one, and if one meets it, then everybody gets the benefit. So as you can see, this doesn't really provide you with much relief. Maybe the children on the farm, but not anybody else.
Is that your children or is that other kids as well?
Your children.
So other kids would be covered?
Yes.
The 30 days, if I hire Jerry today, Bob tomorrow, that's 2 days?
No, that's one for each worker.
So have I used up 2 of my 30? That's my question.
No, you've used up one of your 30.
Okay.
But if you employ Bob for 31 and Jerry for 25, Bob's 31 now covers Jerry. Okay.
And they don't have to be continuous days?
They do not have to be continuous days. It's in a calendar year. How you define that calendar year is up to you. Fiscal, calendar year, or rotating. But yeah.
And length of day does not matter, so 1 hour is a day.
That's right. That's right. So again, there is an exception in the Pennsylvania Workers' Comp Act for ag workers, but it really doesn't hold much weight anymore. Okay, so let's assume there's an injury. The injury happened to someone who is an employee. The injury has to be sustained or has to arise out of something that they did at work or something that happened at work in order for it to be compensable. This doesn't mean that it has to actually happen on the job. The clear example of this is someone has a really stressful day at work and they're upset, they're short of breath, they go home, an hour later, they have a heart attack. And the doctor says, you know what, I think what caused that heart attack was all the stress at work. That's going to be a work injury. So I don't think I touched on this in the very first slide, but the Act is supposed to be remedial in nature, which means everything about the Act and the way it's interpreted favors the injured employee. And I think you can see by some of these things that we're talking about how that plays out. The injured worker gets the benefit of the doubt, not the employer, which makes my job as a defense attorney sometimes tough, and your job as employers sometimes tough. And then we have course and scope of employment. And I won't spend too much time on this because I've sat through 2-hour-long presentations that talk just about this. This is a huge issue in litigation. But basically, if they're on your premises and they're injured as a result of your premises and they had some business reason to be there, that's going to be in the course and scope of employment. Or if they were doing anything that furthers your interests as their employer, that's going to be in the course and scope of employment. Classic example of that one, furthering the interest, is the company that has, a company-sponsored social hour once a quarter and encourages everybody to come because it builds morale and it makes everybody happy and you get along and then it's a better workplace. And somebody gets injured during that social hour. It's going to be covered. That's going to be considered in the course and scope of employment because by participating in that social hour, you were furthering the interests of the employee. So again, really expansive, benefit of the doubt goes to the injured worker. There are exceptions to this. Personal animosity. Basically, if somebody comes on to your facility and they've got it out for one of your employees, and for whatever reason that employee gets injured as a result of that personal animosity, that could be an exception. A violation of the law, if the employee is injured because he was doing something illegal. Classic example nowadays is people driving and texting while driving and getting into an accident. If you can prove that sending the text, the illegal activity, caused the injury, that'll be an exception. Intentionally self-inflicted injuries, you don't have to pay if you have somebody that wants to intentionally harm themselves and they commit suicide or otherwise try to commit suicide while at work. And intoxication. But again, the intoxication must have actually caused the injury. I had a case one time where we had a worker up on top of a roof and had a few beers at lunch, so was technically intoxicated under the legal definition. But it was a really crazy, windy day, and he fell. And he made the argument, it doesn't matter that I had a few beers. I have a few beers every day at lunch and get up on the roof and fix the roof. And I never have a problem. The reason I fell this particular day is because of the wind. And he won. So you have to be able to prove that it was the intoxication that caused the injury. So just to sort of highlight that point, are any of these in the course and scope of employment? An injury sustained while commuting to work is generally not going to be compensable. Going and coming is accepted. Injured while en route to the bathroom at work, yes. That's called the personal comfort doctrine. Your employees are expected to be able to go to the bathroom while they're at work, so if they get injured while they're there, you're going to pay for it. Employer-sponsored wellness programs, maybe. Again, was there some employer interest that was being furthered? For bigger employees, I would say if you have a wellness program or support wellness and it reduces your health insurance premiums, it's probably going to further your interest. Injured while goofing off, maybe. Depends on whether or not you have a clear rule against goofing off. Generally, I think they're going to be covered because to have the rule, it needs to be written down. You need to tell people, and you need to routinely enforce it. And one of those things usually exists, but not all three. Injured while driving coworkers home from a social event, I talked about that one. And injured while performing Good Samaritan duties. This comes up sometimes. you know, somebody's stuck on the side of the road, you stop to help them out, their car gets dislodged from being stuck and it runs over your foot. Well, it depends on why you were helping that person, who you were helping. If it's just, you know, Jane Smith that isn't related to your employer, then probably not going to be covered. But if it's a coworker and you were helping them get unstuck so that they could get to work, probably will be covered. So then we talk, once we know all of that, then we talk about causation. And causation for workers' comp is different than causation really for anything else, okay? Because disability under the Workers' Comp Act has a very special definition. It means wage loss. It doesn't mean an injury. Injury and disability are two separate things. So if I'm injured and I have wage loss, I have to show that my wage loss is caused by my injury, okay? So I have a back problem. My doctor says I can't work. My back problem stems from work. My disability is caused by my injury. If I have a back problem, I can work, and the reason I'm not working is because I failed a drug test. My wage loss is not caused by my injury. You see the difference there? Okay. So there's two types of disability. There's partial disability, where the employee is working, but they're not earning as much as they did at the time they were injured. Injured workers get partial disability benefits for 500 weeks. It's about 9.6 years. Okay, that's a long time. Total disability, where an employee is unable to earn any wages as a result of his or her injury, is potentially payable for life. As I said, wage loss that isn't caused by the injury is not compensable. So if an employee voluntarily retires, if they're incarcerated, if they're terminated for violating a work rule, etc. It's important that you know about notice requirements. Your employees have 120 days from the date they're injured or the date they know they're injured to tell you about the injury. They don't have to use any magic words, and if you saw it happen or you know it happened, then the employee doesn't even have to tell you. So you just have to be on notice, let's say, within 120 days of the injury happening. It's important that you remind your employees about the Workers' Comp Act. You know, we don't want them filing frivolous claims. We don't want them filing false claims. But what we really don't want is them having a real, true claim and them not telling you about it for some reason. Because everybody benefits by early notice. Why? Well, I had a case recently where a welder cut his finger. More than a paper cut, but nothing huge. And he thought, oh, I'll take care of this myself, wrapped a Band-Aid around it, performed first aid. When he got home later that night, it got horribly infected because he didn't properly treat it when it happened, and he ended up losing the tip of his finger. Now, if he had reported that cut to his employer at the time it happened, they would have sent him for first aid. It would have cost them $150 for the doctor visit and the first aid, and that would have been it. Okay, so benefits the employee, benefits the employer. Because he didn't notify them, because he tried to treat it himself, the employer is now paying for antibiotics, treatment, the surgery to remove the finger, and specific loss, because loss of a finger is additional benefits. So let's talk a little bit more about the benefits that employees get. Wage loss, that's the big one, is paid during any period of disability. Again, disability is wage loss of any kind, whether it's full or partial. You know, for example, you have an employee who works tons and tons of overtime, and they get injured, and now all of a sudden they can only work 8-hour days, and they're not getting overtime. They technically have wage loss. They technically have a disability because they're not earning as much as they did. We call this indemnity benefits, TTD, TPD. So if you're talking to insurance carriers, you might hear those words, so I just wanted to make you aware of it. There is a formula set up by the Department of Labor and Industry that you can find on their website. I know this is kind of small, but there's these blocks here that tell you exactly how much an employee is going to get in wage loss. So you take their average weekly wage, usually over the past 13 months. If they've been employed by you for shorter than that, there's other ways of calculating it, on the date of injury. Okay, that's the magic date. And then generally, their comp rate's going to be about 2/3 of that, tax-free. So at the end of the day, what they get in comp is supposed to equal out to what they would get after withholdings and deductions for taxes. Okay. So just an example, the maximum comp rate in Pennsylvania right now is $951. So a highly compensated person, no matter how much they receive per week, that's the max they can get in workers' comp. But as I said, let's just assume that they're able to receive that for the full 500 weeks of partial disability. That's $475,000 in wage loss. I mean, it can really add up. The minimum is 90% of whatever the minimum is. So you've got part-time workers, they would get 90% of whatever their part-time wage is. So, you know, it can add up for them too. The other really expensive part of workers' comp is obviously the medical, especially with pain conditions where people have to go pain medication and epidurals and see pain specialists. If it's a reasonable medical treatment, if it's a necessary medical treatment and the treatment is related to the injury, you're on the hook to pay for it. And responsibility to pay medical benefits for a work injury is for life. Okay? And once the obligation to pay starts, you can't just stop. You have to file litigation in order to stop it. Litigation means lawyers. Lawyers are expensive. So again, you know, medical benefits is a really high cost. So panel providers, I won't spend a whole lot of time on this, but it's just important for you to know. Your insurance companies should have these lists for you. And so if you don't have the list, ask for one. It's a list of doctors that the insurance company has said we will be okay with your employee going to for treatment. And the really nice thing about the Workers' Comp Act is within the first 90 days from the date of injury or the date that you're notified of the injury, you get to send the employee to one of your doctors, the doctor on the list. And that helps you and your insurance company really control the cost of care. And hopefully if you can get them healed and feeling better and back to work within that 90 days, it keeps your costs down. Now, after the 90 days, they can go see whatever doctor they want. But within that first 90 days, if you have a panel list, and if you have provided that panel list to your employees, then they have to go to one of those doctors. If you don't have the list and you don't provide it to the employees, then they can go and treat with whomever they want. So keep this slide, put a note on it to call your insurance company so you can get a copy of that list. Okay. Other benefits. Again, as I said, there's no punitive damages and there's no non-economic damages, but there are a lot of other types of economic damages. So death benefits are payable under the Act. That's coverage for funeral expenses and expenses related to death, but it's also dependency benefits to either the widow or the children. Children get survivor benefits until, I want to say, I haven't looked at this in a while. It used to be 18 and then they changed it. Now I think as long as they're a full-time student in school, they can continue to receive survivor benefits. Statutory interest is at 10% under the Workers' Comp Act. So if any payments are late and have to be paid late, you're going to get 10% tacked on top of that. Litigation costs mean whatever it costs the injured worker to fight you for payment. Court costs, transcript fees, medical record fees, things like that. That's different than attorney's fees. And when I say counsel fees, I mean not only the counsel fees that you have to pay your defense attorney, but also generally employers pay the claimant's attorney's fee if the claimant is successful. So what usually happens is, let's say your injured worker is entitled to receive $500 a week. The employee gets 80% of the $500 and the attorney gets 20% of the $500. If for some reason you do something unreasonable or you violate the act in some way by not paying benefits when you're supposed to, by unilaterally stopping payment of medical benefits, then they can tack the attorney's fees on top of the wage loss. So it would be $500 to the employee plus the attorney's fees. Now I will tell you that happens very rarely. Usually claimant's counsel takes their 20% off. There's also penalties that are payable if the act is violated in some way. But the other big ticket item is specific loss. What that means is any disfigurement of the head or neck that's visible, and then loss of limb, whether it be finger, leg, arm, eyes, loss of hearing. And it's kind of morbid. The legislature actually went through and assigned a certain number of weeks to each body part. So I think I have it up there. An arm gets you 410 weeks of benefits. So if your benefit rate is $475.50, you get almost $195,000. So that's what your arm is worth, according to the state of Pennsylvania. And that's all statutory.
On the specific loss, is it safe to say then that a lawyer's arm is worth more than a McDonald's arm, a McDonald worker arm?
It is, isn't that awful?
Okay.
Yep. Yes, because it's a fixed number of weeks times your benefit rate. So yes. And I will say that for loss of limb, we have specific numbers of weeks. For scarring and disfigurement, it's a little bit more arbitrary. So the judges usually determine, so let's say somebody has like a huge scar here because they had a cervical surgery, the judge would determine what that's worth. There's no specific, if it's 1 inch, it's worth this much. If it's 2 inches, it's worth that much. So there's usually litigation associated with that.
Is that bottom figure there, 194,000, is that for medical or is that for loss of wages? Or?
No, that's in addition to medical and lost wages. That's just paying a person for losing their arm. Literally, this is what their arm is worth.
And that's one lump sum? Okay. And then the medical would be different?
That would be on top of it, right?
Okay.
And if they can't work as a result of their arm, then they would continue to receive that $475.50 for every week that they can't work. You can see how expensive it can get. And this is why you'll have coverage, right?
Can I ask you a question related to that? If you have an injured person and they're getting workers' comp and they don't settle this over a number of weeks for years, can they also apply and get Social Security disability benefits, or are they mutually exclusive?
No, you can earn workers' comp and Social Security disability at the same time, but the total combined benefit of the two cannot exceed 80% of their pre-injury wage.
Okay.
Yeah.
Question on that.
Yep.
If you offer another work, for that person that they can do.
Yep.
Is that, then can they still claim that they don't want to do that and not take the wage loss?
They can claim whatever they want. I would say you'd have a pretty good argument, though, to stop them from getting benefits. So let's expand the scenario a little bit more. So you've accepted their injury. They've been out for some period of time, let's say a month, okay? And then their doctor says they can come back to work in some capacity. And you say, okay, I have work for you in that capacity. Make sure you tell your insurance company, first and foremost, your insurance adjuster, that you have this work and you want to make them the job offer. And the insurance company then has some legal obligations and forms that they have to fill out and send. And then you tell the person, hey, we've got work for you, come back to work. If they don't come back, then again, you tell your insurance adjuster, and your insurance adjuster will then have to file a petition to stop their benefits. And you'll have a pretty good argument in court to get those benefits stopped. If they come back to work, then you tell your insurance adjuster, and the insurance adjuster fills out a piece of paper, and their benefits stop. So you might have to do a little extra work to get the benefits stopped if they don't come back, but it's definitely in your interest to make that job offer if you can.
So if you have an employee that reports an injury, you need to report it to your carrier pretty quickly. And your carrier can help you with the reporting to the state. We talked about that list of panel providers. Make sure you get that from your carrier and provide that to your employees. And then assist the insurance company with any investigation that they want to do if it's questionable, for example. Again, I'm very cynical. I've been doing this long enough that I see lots of questionable claims come in. It's a Monday morning at 9 o'clock and we know the person was out doing whatever kind of adventures over the weekend and all of a sudden their shoulder hurts or their back hurts, right? So if you question it, if you don't trust your employee completely, make sure you tell your insurance company about that too and help them investigate. There's a really short window of time to conduct that investigation. It's only 21 days. So you gotta get on it. Okay. Just a quick note about injuries that are caused by third parties. Just because the employee is collecting benefits from you doesn't mean that they can't also sue that third party that caused their injury. Classic example of this is if you have somebody, let's say, driving for you to deliver something and they're injured in a motor vehicle accident while they're out on the road. They get workers' comp benefits for you because they were working for you at the time of the injury, but they can also file what's called a traditional suit in tort against the person that hit them in the car. Okay, they don't get to double recover though. Every benefit that you have paid to them becomes a lien against any recovery that they would get in the other lawsuit. Now, that lien is reduced slightly by the cost of recovery. So basically they go and hire an attorney. The attorney helps them get that money from this third party. You have to pay some of that attorney's fees, but it just comes out of the lien. So there's no double recovery. So that's just important to know. And if you have an employee that's a really good employee and they have been hurt like this, you might want to just mention to them, hey, did you know you can also file suit against the person that actually caused your injury? You can't force them to file suit. It's their right. But you can certainly let them know that they have the ability to do that.